Thank you very much. My name is Tom Shepstone. I'm a planning consultant. I'm from Holmesdale, Pennsylvania. I've been a professional planner since 1973 and consulting practice since 1977. I've done work for some of your other townships in Lackawanna County, including Covington and Scott Township, where I wrote Scott Township's first zoning ordinance, for example, rewrote Covington's. I've written dozens and dozens of zoning ordinances and land use ordinances in both New York and Pennsylvania. And I appreciate the opportunity to be here tonight because I'd like to talk to you about some of the ordinances that are being proposed to you, particularly the ones that would ban gas drilling in this township, because I have a great concern about them. But before doing that, I want to mention I also have a consulting contract with Energy in Depth, which is an industry-supported organization, so I want you to know that I have that perspective. But I do that because I believe in that. I believe this is something vitally important to our region, and that's why I got involved in it. But let's talk about the ordinances, and I specifically want to talk about the type of ordinance that's been proposed to you. I don't know if you've got a draft in front of you yet or not, but I know you've talked at one point at least to the Community Environmental Legal Defense Fund. I'll just refer to them as the LDF, Legal Defense Fund. I know that from reading the newspaper that Ben Price was here to talk with you about the proposed ordinance. And I think it's vitally important that you know who that organization is, what they're about. And I'm going to leave you with everything I've got in my hands here, but I would encourage anyone who has not done so to go to their website, because when you go to their website, you'll see what they're about. They're a very radical organization. They have a page on home rule, which is what their claim to fame is, to propose home rule types of ordinances and local laws. They are funded by, in part at least, by a group called the Park Foundation, which is out of Ithaca, New York. It's a very left-wing organization that funds all kinds of radical environmental causes, including the LDF. And they run around the country, particularly in Pennsylvania, but elsewhere as well, proposing these home rule ordinances with the idea that you can essentially overrule the Commonwealth of Pennsylvania itself and even the federal government, that you have it within your power, even though you're a creature of the Commonwealth of Pennsylvania and created by the Commonwealth of Pennsylvania. You have it in your power to overrule the Commonwealth and also to overrule the federal government. And in fact, they put on their site a list of ordinances that they've developed models for. And if you go on there, they have one that says you can overrule the Patriot Act. Do you believe that? No, you don't. You don't believe that you can overrule the Patriot Act, but they do. And that's the problem. They believe that you can prohibit corporate ownership. They believe you can say that a corporation shall not do business in this township, that a corporation cannot do land development. That's what they believe. You don't believe that. You know that's not true. And they also have several ordinances against corporate agriculture. Well, I see Keith Eckel in the audience tonight. And I'll bet, I don't know this, but I'll bet Keith operates some of his business as a corporation. Are you going to tell Keith Eckel that he can't operate a farm as a corporation? And you're going to tell any other farmer who does this for state planning purposes they can't operate a farm or do a business as a corporation in this township? Well, that's what this group thinks you can do. This is what this group thinks you ought to do. And they advertise on their website, they advertise a ordinance that they're very proud of in Blaine Township out in western Pennsylvania. And interestingly enough, they've lost the battle there. There's a great article. I'm going to leave it with you. That talks about how they lost that. Even though it's still prominent on their website as of today, they lost that battle. And it talks about in this article the fact that what it says what the LDF lacks, according to critics, is a track record of court victories. And it talks about Judge Ambrose, who in 2 decisions effectively wiped out large parts of the ordinances, finding that Blaine, I quote, does not have the legal authority to annul constitutional rights conferred upon corporations by the United States Supreme Court. Their ordinance was so radical that their own insurance company filed a complaint against them saying, we can't defend you and we won't defend you because what you're doing is so wrong. And I want you to bear that in mind. I also would encourage you, it's very easy to go on the web these days and look at any nonprofit corporation and look at their 990 filings, the 990 tax return that every nonprofit corporation has to file. The one from 2009 is particularly illuminating because in the back of it, it tells some of the stuff they did. The same thing as in 2008, which I'll leave you with. There's 3 cases mentioned in here relating to township ordinances. They are ordinances that are designed to prohibit gas drilling and various types of mining. I'm not going to bore you with all the details. I'm going to leave you with all this. But it says, for a case of the first one, which was against a coal company, the court declared that the ordinances were preempted by state coal extraction laws and the corporation was entitled to the full range of constitutional rights possessed by natural persons. The municipality chose not to repeal the ruling, so they lost. The second one, Range Resources. This was a gas case. In her final ruling, the federal district court judge ruled the ordinance fees violated state preemptive schemes and that the Natural Gas Corporation was entitled to the full range of constitutional rights possessed by natural persons. The municipality chose not to appeal the ruling. They lost that one. And the third one, this was another case against the Packer Township Board of Supervisors in Carbon County. And in this case, they again lost. This had to do with spreading sewage sludge on land. And they basically said their defense of all this is to say the Legal Defense Fund is challenging several legal doctrines that interfere with the ability of the majority to govern itself within the community. And once again, they lost. And I could give you the other one from 2008. There's a fourth one there. So 4 cases reported in 2 years, and their 2 latest tax returns. 4 cases where they represented townships. They lost every single one of them, where the court essentially laughed them out of court. That's who's been advising you. Now, I'm not saying you're taking their advice, so please don't misunderstand me. You're in a difficult position. But they are being purported as experts to you, and that's who they are. They've also developed an ordinance for Harvey's Lake, which was turned down by the Harvey's Lake Borough Council by a vote of 6-0, after their solicitor told them they'd be fools to pass it. And in this ordinance, which I suspect is probably the same thing they would offer to you if you were to take their advice, they talk about something called the rights of natural communities. And they define the beneficial use of water as a fundamental right of natural communities to water. Well, what's that mean? Well, the LDF is a proponent of something called natural rights, rights of natural communities. And they have a separate section in here on that. And it says, no private claim to ownership of natural communities, ecosystems, or the genetic material of any organism shall be recognized within Harvey's Lake. Residents of the borough shall possess legal standing to enforce these rights on behalf of the natural communities and ecosystems. What that means is the rocks and the trees have as much right as human beings. You don't believe that. And this is why this is crazy stuff that they're proposing. They also say, nor shall corporations possess the authority to enforce state or federal preemptive laws against the peoples of Harvey's Lake Borough that would have the effect of nullifying this ordinance. And corporations shall not be persons within the United States or the Pennsylvania constitutions or under the laws of the United States, so on and so forth. So once again, you know what the courts have said. Corporations can be persons. That's affirmed by the Supreme Court of the United States. And yet they're trying to tell you that somehow you can change that. You can overrule everybody, Supreme Court included. And they go on to say corporations are not afforded the same rights as borough residents. And the corporations that violate the ordinance shall not be afforded the protection of the Contracts Clause or the Commerce Clause. So they can literally write a contract, they can throw out the Commerce Clause because somebody didn't follow this ordinance. That is absolute nonsense. And it goes on and on. But the point is, this is what's being proposed to you. Now, what can you do? Let's look at the positive side of this. There has been some case law that's come down. There are 3 cases in particular, one in the borough of Oakmont, another one in Salem Township, and the third in Fayette County, which involves zoning ordinances. In those 3 cases, in Salem Township, the Supreme Court threw out an ordinance because the ordinance essentially said we can turn down your permit for any reason. You know, made it a conditional use or a special exception, and then didn't have any criteria. Said you can throw it out for any reason. Well, the court said you can't do that. That's clearly against the state preemption. It's clearly against the whole notion of the way Pennsylvania has treated this. In the borough of Oakmont case, the ordinance was sustained because in that particular case, what they did is they said we're not going to allow drilling in a small R1 area of our community. And that's something that has been upheld. It does not mean that you can prohibit it in the entire